just to make sure in terms of what's not been entered. Just make sure we got everything in. I'm not sure what that is. I guess we don't need. I guess we don't need these things. I'm just not sure what some of these are. This stuff we don't need definitely.
No.
Okay. So I'm just not.
I think we're fine. The photos were just photos of the firearms. I don't think
So
we
these,
need that.
okay, so we don't need Q. I think that was the line she said was the line.
Right.
So
Phones,
I'm not
we
sure
don't
what the
need.
phones are, but
We have photos of the paperwork and his IDs.
I'm not sure what that. All right, so we're fine with it.
I think so. That's right.
Please be seated. Ladies and gentlemen of the jury, thank you so much for coming back. Thank you for being on time. We appreciate that. I need to ask you some questions. You know what they are going to be. Has anybody contacted any of you or approached any of you since you left here the other night for after service on the jury and before you came back this afternoon? Anybody contacted you? Raise your hand. I don't see any hands. Has anybody conducted any research? See anything on the TV, newspapers, any news periodicals, any other magazines or any other sources, internet, Facebook, or any other internet item about any of the issues, any of the parties, any of the attorneys, or any of the witnesses? If they have, please raise your hand. And I don't see any hands. And has anybody here seen any of the other jurors conducting what appeared to be research on any of the issues in this case? If they have, please raise your hand. I don't see any hands. Thank you again for being on time. This is going to be a little bit of a different day. We're starting halfway into the day. As you know, we had something we had to cover this morning. We're going to have you up and down a little bit back into the jury room. You do have your pads. So I'm going to call on the state now, and then we'll kind of move into different things. Mr. Mallett, call your next witness, sir.
Your Honor, the state rests at this time.
Ladies and gentlemen, at this point, and we talked to you about this in opening statement and the initial instructions I gave you, at some point the state would indicate that they have presented all of the testimony and all of the evidence that they wish to present. The state has now done that. They are resting their case, meaning they have no additional evidence to offer, no additional testimony to present at this time. I need to spend a few minutes with the attorneys at this point, since the state has rested its case, so I'm going to have you go back into the jury room. We will try and get through things as fast as we can, and we'll get you back in here. Please, I mentioned to you about bringing something with you to keep you busy back there today. We'll be as quick as we can. You do not discuss the case. Jury action. Please be seated. Mr. Davis, the state has rested. Do you have any motions to be made at this time, sir? Yes, Your Honor.
May it please the court, Your Honor. I would like to make a motion for judgment of acquittal Your Honor, the state of Florida has not met the threshold requirements to establish that Bessman Okafor burglarized the dwelling with an assault and with a firearm. They have not met the threshold requirements for robbery with a firearm in any way, have not met the requirements for any false imprisonment with a weapon, or the threshold requirements for
Yes, Your Honor.
yeah, and I apologize for that. For aggravated assault with a firearm, Your Honor, they've failed to identify my client, which is one of the key elements. Not proved that he possessed the gun in the case, that he was not in the vehicle when the guns were found. There was no DNA evidence on the guns that would apply to him, no fingerprint evidence. And so I would respectfully request and respectfully make this motion for a judgment for acquittal of the charges against my client, Bessman Okafor. No, Your Honor.
Your Honor, the state has met its burden in terms of presenting evidence as to all the charges. You have multiple witnesses ID, Mr. Okafor, as well as him being in possession of items specifically identified by all the victims as having been taken from the house as a result of the burglary. It's also the presumption that possession of recently stolen property. Mr. Okafor was also observed in proximity to two firearms that were recovered from a vehicle, and the court knows the testimony in terms of all the items recovered from the vehicle as having been in his custody and control. The state has met its burden in terms of these counts, Your Honor.
May I just make one response, Your Honor, just for the record? That, Your Honor, possession of stolen items, strike that, possession of items does not mean that they were necessarily stolen, just for the record. And I would like the court to consider that in making its decision.
On behalf of Mr. Bernard, I'm actually going to second a lot of the motion that Mr. Davis just made, and also add that in regards to the firearms, and in light viewed most favorable to the state, while the state has shown that there were firearms recovered in the vehicle, they have not made any connection that these firearms in the vehicle were the firearms that were used in the alleged robbery. In fact, I think specifically Ms. Brianna Campos testified that the guns one was completely black, and from my recollection of the pictures, both guns were black and silver, indicating that perhaps these were different weapons that were recovered. And therefore, there's no connection that the weapons that were recovered were actually the firearms that were used in the robbery with a firearm. Because of that, we don't know if there were actually guns used in the robbery with a firearm, if they were working, if they were toy guns, if they were something that just looked like a gun. Like I said, the firearms recovered do not match the description that was given by the victims in this case. That's it for.
And Your Honor, the same argument, multiple people identified Mr. Bernard. Mr. Bernard, again, was also found in possession of some of the items identified as having been stolen from the house, and he was, again, in close proximity to one of the firearms, and it's a question for the jury to decide whether or not that's the firearm or not, but certainly the state has met its burden in this case, Your Honor.
The answer is yes, Your Honor. Yes, Your Honor. Yes, Your Honor. My first witness, Your Honor, is Officer Dewey Mullen. Yes, Your Honor, I understand. But the answer is no, no more than Officer Mullen at this point.
Jury entering. Please be seated. You'll notice we want you to get your exercise. We're going to do back and forth. I did not ask. You all have your pads. Does anybody need additional paper? Does anybody need an additional pen? Are we okay with the pens, papers? Very good. All right. Mr. Davis, call your first witness.
Please, the court, Your Honor. The defense for Mr. Okafor calls Ocoee Police Officer Dewey Mullen. Dewey Mullen. It's Deweymullan. Yes, sir. Thank you, Your Honor. And thank you for appearing again, Officer Mullen. Briefly, if you could, would you refresh the memory of the jury with your background? How long have you been an officer with the Ocoee Police Department, sir?
8 years, sir.
And in what different capacities have you been chronologically in those 8 years?
A patrol officer, I'm a corporal, a traffic officer.
Okay. And briefly, could you go through your training during that time of your service with the Ocoee Police Department?
You mean all the training I've attended?
The training yes, the training that you've attended.
10 block training once a month on Fridays. For 8 hours, I've attended other classes. I'm a firearms instructor, defensive tactics instructor, and edge weapons instructor.
Okay. Tell us about your formal education training. Sir, did you go to university?
No, sir, I did not. High school graduate.
High school graduate, and then you applied to the police department?
High school graduate, and then I served 3 years, 3 months, and 18 days in the Army. I'm a veteran of the First Gulf War. After I left the Army, I went to the police academy in Withlacoochee, Florida, and got my state certification to be a police officer, and that was in 1991. So I've been 20 years as a police officer, a little over 20.
Yes. Okay, and in those 20 years as a police officer, you've never had a reprimand for not telling the truth, have you, sir?
No, sir.
Right. And there is no reason to believe you were not telling the truth on the stand the other day on September 13th, 2013, is it?
No, sir.
And officer, because you are professionally trained as a law enforcement professional, you do understand why you take an oath to testify in court, don't you?
Yes, sir.
And you do understand, again, you do understand what that means.
Yes, sir, I do.
Yes, sir. And what does that oath mean to you? Please tell the jury.
Judge, I'm going to object to relevance and bolstering.
Thank you.
What that oath means to me is that if you lie, if you knowingly go into something and lie, you're wrong. You conspire to make up a false or untruth. That's what that oath means to me.
Yes, sir. And as an officer, you've taken many oaths in testifying in for the state in the past, haven't you?
Yes, sir, I have.
That's part of the job.
Yes, I have.
Yes, sir. And officer, you do remember taking the oath before testifying here on September 13th, 2013, this past Friday.
Yes, I do.
And you took that oath, I should say, to testify truthfully.
Yes, I did, and I did.
Yes, sir. And when you came to court this past Friday, September 13th, to testify, is part of what you do to testify in the capacity with which you do professionally, part of that is preparation. Isn't that correct, sir?
Yes, sir.
And officer, on September 13th, this past Friday, when you testified, you did tell the truth when you were on the stand, didn't you?
Yes, sir, I did.
And you did know that you would be testifying.
Yes, sir.
And you did prepare to testify this past Friday, the 13th.
Yes, I did. I obtained a copy of the report. The report was a little over 210 pages. I got like the 20 pages that pertain to what I did and brought it with me.
Okay. So in essence, you would not be here testifying to tell the jury a lie, would you?
No, I would not.
Well, officer, do you recall on September 13th when you testified in this case, that you testified that all the witnesses told you that the home invaders on May 9, 2012 at 503 Bernardino Drive, Coy, Florida, wore masks during that crime?
Yes, sir. I said that one of them, or they were all of them, they were all standing together, they were crowded around me when that was said. And I probably needed to clarify that mask thing also.
Well, I have no further questions, Your Honor.
It's my intention to present some evidence through him, but I'm not going to cross-examine him as to anything Mr. Davis just asked.
Thank you, Judge. You said you wanted to clarify something about the masks.
Yes, sir. Now, I got there at about 1:38, and I believe about 1:46, I got that GPS tracker working, and I was able to see. Well, all the boys were crowded up around me, and I believe Officer Hampton was talking to the girl that was involved in this case. The fire department was on the way. They were already there. The neighbors were coming out, obviously, to see what was going on. There were a lot of people around us. Well, I'm sitting there doing this app, and everybody's looking, and the one boy said, just out of nowhere, it didn't catch me for a second because it was reported that they weren't wearing masks. One of them said that when the guy grabbed him, was that he had his T-shirt pulled up over his face like a mask, but he couldn't hold the gun, grab him, and keep it pulled up at the same time so that he'd come down. I didn't count that as a mask, but when you asked me the other day, I was like, well, I swore to tell the truth, and the guy said he had it covered briefly, but I didn't write the offense report. I just wrote the investigative report.
Okay, so previously when you said you thought there were masks, they wore masks, that's what you were referring to?
Only one of them,
Okay.
and that was the one that got the boy up, grabbed him, had a gun on him, but he was using the shirt pulled up over his lower.
As you sit here today, do you recall anything else about whether or not any of the people had said they were wearing masks?
No, sir.
Thank
They
you.
were all standing there together, though.
Thank you, sir. No further questions.
Officer Mullen, again, you took your oath to testify truthfully.
Yes, sir.
And so isn't it true that today's testimony that you just gave to my esteemed colleague from the state on his cross, wasn't that different?
Judge, I object to leading and argumentative.
Officer Mullen, wasn't that different from what you testified to today?
I believe it was the same. I just clarified it a little bit more. I went into it.
Officer Mullen, you just testified that you recalled that on Friday, September 13th, in this courtroom on this stand, you testified that witnesses told you that the people who perpetrated that crime on May 9th, 2012, at 503 Bernardino Drive, Ocoee, Florida, wore masks.
Yes, sir. I believe I said that one of the boys, one of them, had told me they were all standing there in a group, but only one of them was wearing a T-shirt pulled up, not actual mask.
You do recall that you said that they wore masks?
No, sir.
No more questions, Your Honor.
Yes, Your Honor. So I'm going to go ahead and have you step down. I do need you to wait outside, though, please.
Yes, sir. Thank you.
Defense for Mr. Okafor, Your Honor, has no more with race.
Folks, I'm going to ask you to step back in the jury room for just a few moments, if you would, please. Jury acting.
That is correct, Your Honor. That is correct, Your Honor. Yes, sir.
Good afternoon. How you doing? Yes, sir. Yes, sir. Yes, sir. Yes, sir. That's correct. the same officer doing both.
Yes, sir.
Sir, if you would, just tell the jury and the court one more time your name.
Dewey Mullen. Yes, sir.
Thank you. Good afternoon, sir. Welcome back. Been a long time, I know. All right, I'm going to show you what's been marked as State's Exhibit 2. You recognize this? Oop, let me back out.
Yes, sir.
All right. And that's a silver wallet, right?
Yes, sir.
With some of Miss Campos's stuff?
Yes, sir.
All right. Are you looking at something in particular?
Look at my report. My report. Yes, sir.
Okay. Well, you know what this is by looking at it, right?
Mm-hmm.
All right. Now, you took this out of Mr. Bernard's pocket, right?
No, sir, I don't believe I did.
Isn't this the one thing you took out of Mr. Bernard's pocket?
I think this is in the backpack, I think. I gotta look at my report to make sure.
Okay. If you think that'll refresh your memory, go ahead.
Yes, I recognize it. But I didn't take it out. I believe Officer Byrd did. Yes, sir. It's been a while back. It's the 2012 case.
Right. You got your deposition was taken back in November 5th, 2012.
Okay.
Judge, I'm going to object. Can we approach?
So, officer, you were asked what you did back at this deposition November 5th, 2012, and your statement at that time was, this is page 14, line 11, which is what I was open to when I gave it to you.
Yes, sir.
And your statement at that time was, I did retrieve a silver credit card holder that belonged to the girl in this case. It had her school ID in it, her credit cards, all that stuff. That was retained, and I took a property receipt on that, and then that was returned to the victim, I believe. Question was, okay. Your response was, that was the girl, he had her credit card in her pocket, in his pocket. What was found on him? Question, would that be Brianna? Your answer was Brianna. Question, okay. Answer, had her picture ID or school ID?
I don't object to reading the whole portion of the transcript. I'm not sure what portion he's.
If I may, Your Honor, there is more to it. I understand, Your Honor.
And then we have the same objection, Your Honor, impeaching a witness, calling a witness to impeach him.
It is, Your Honor. You said had her picture ID or school ID, her credit cards, just the usual stuff in a little card holder. Question, okay, and that you personally? Answer, that I took that out of his pocket. Question, out of his pocket? Answer, mm-hmm. Question, okay, and then did you take anything else from him or find anything else on his person? Answer, no. That was your testimony at your deposition on November 5th, 2012, right?
Yes, sir.
That this wallet with Ms. Campos's school ID and credit cards were taken out of Mr. Bernard's pocket by you, personally.
I believe Officer Byrd had taken it out of his pocket.
All right. My question was, when you were asked about this in November 5th of 2012, you said that you personally took this exhibit that is on the screen from Mr. Bernard's pocket.
Yes, but up here on the top it says, but you were not the person that retrieved it, and I said no. And the person said okay.
Okay. Your Honor, can we read that then? If that's, put that in
I
context.
think I was thinking two different things.
The answer there was, oh, in Mr. Bernard's pocket there was the property sheet's not listed here in this one, but I can give you the approximate, oh, let's see. He had a phone in his pocket, but that was Officer Byrd who took it from him.
Correct.
Right.
I believe she also found this credit card holder too.
When you were asked about it, you said you took it. You personally took it out of his pocket. That's what we just read. You and I together, we just looked at that.
Yes, sir. I believe I was wrong in this then. Or they didn't understand me. I don't know what the was. Sure. About 6'1", 6'2", maybe. 6 foot is very much. Thank you very much. I know for the question. No, Your Honor.
Yes, Your Honor. Thank you. Sir, you indicated it's been some time since you did the deposition.
Yes, sir.
I hadn't had a chance to review that before looking at it today.
Reviewed it, I got ready to go to court on Friday. Got my pages out.
As you sit here today, do you remember whether you took custody of the credit card holder or whether it was Officer Byrd?
In my report, reading my report, it was Officer Byrd that took it out of his pocket and the cell phone.
Okay. So Officer Byrd took it out of the pocket. Were you involved in examining the wallet there?
Oh, yes, I was.
And so were you the person that found the credit cards and all that?
Yes, I was.
Thank you. Please proceed.
Any recollections?
No, Your Honor.
Can this witness be excused, Mr. Clark?
Yes, Your Honor.
Mr. Davis? Yes, Your Honor. Now, this witness be excused.
Yes, Your Honor.
Thank you, sir.
Ladies and gentlemen, once again, I know that you're doing this, but I'm going to ask you to step outside into the jury room. Please do not discuss the case amongst yourselves. Do not discuss it with anybody else. And do not do any research. Leave your pens on your chairs. Jury. Please be seated. Mr. Clark, you had to speak with your client about testifying in this application, and to be comfortable, you have to not speak with him, and it's your understanding that he is not willing to testify against you. Mr. Bernard, I need to ask you some questions, sir. You understand, sir, that you have a right if you prefer to remain silent. You need to voice up a little bit for a court here.
Sir.
You understand also that you have a right, if you wish, if you were right, to get on the stand and testify in this matter.
Yes, sir.
What you need to say, if you do, not only does your attorney have a right to ask you questions, but the state will have a chance to ask you questions, and Mr. Davis will have a chance to ask you questions. You understand?
Yes, sir.
You also understand that you can assert your right to remain silent, stay off the stand, and not testify, and the jury will be told that they are not to consider the fact that you did not testify in this case. You understand?
Yes, sir.
You had a chance to discuss that with your attorney.
Yes, sir.
Are you comfortable that you've had sufficient time to speak with him about it?
Yes, sir.
And it is your decision not to testify in this case, is that correct?
Yes, sir.
And Mr. Clark, you are representing me, is that correct?
That's correct.
Mr. Blount, do you have any rebuttal testimony that you'll be presenting in this matter?
Yes.
Let me see counsel with that, please. Ladies and gentlemen, you have now heard the state's case, the defendant's case for Mr. Bernard, the defendant's case for Mr. Okafor. The two items remaining are the jury instructions and the closing arguments of the attorneys. One of the things I was doing while you were back in the room is trying to do some time calculations because it's about 2:30 at this point. We have to get the jury instructions finalized and the verdict form finalized for you and get those in preparations. Remember, I told you we give you a copy of those actual instructions to take back with you, so we need to make sure that we have them in the proper order to take back. In addition, we have the closing arguments of the attorneys, and I explained to you what those were. That's where the attorneys are taking the testimony that was presented, the law that you're going to be given, piecing it together and giving you their thoughts with regard to this particular case. While that's not evidence, you will find that extremely helpful to you in deciding this case. When I ran the mechanics of it time-wise, that's going to run late into the evening, and we don't want to do that to you. We are going to finish this case tomorrow, and instead of working you late tonight, what we're going to do is probably go ahead and send you home. We're going to stay in this courtroom and work, probably up till 5, if not later, to get ready for you. When you come back tomorrow at 8:30, we will start with the instructions and the closing arguments, and once those are completed, it will be handed over to you to decide this case. So probably around noonish tomorrow, you should have this case. Noonish sounds like a weird term, but around noontime, you should have this case tomorrow. I know that's kind of a waste of this afternoon for you, but we're afraid that if we start and then we have to break up things in the middle, you'll lose some continuity of what's going on. You came back today, we were able to get this taken care of. We don't want to have you just sitting in that jury room for 2 hours while we're going over these things here, calling you back in for a half hour, and then sending you home and having you come back. So I think this will work out better by sending you home now, asking you to come back tomorrow, especially with you knowing that that's the final day you'll be coming back on this matter. It's extremely important that you do what you have been doing so well, and that you refrain from watching anything on the news, refrain from doing any research on the computers, refrain from listening to anybody else about this case or seeing things on the TV, just for one more day, if you would, please. When you hear the closing arguments, and I'll give you an approximate. The closing arguments are going to probably be an hour to an hour and a half from each of the sides, so you can see the time frame is going to pretty much fill the morning for you, and then it's going to be turned over to you. But I need you to keep an open mind until you hear the law and until you hear those arguments. You will have a copy of that law in your lap. You'll have the arguments coming to you from the attorneys suggesting what they think the resolution of this case should be and why they recommend that to you. And then you will go back. We will not bother you at all. We won't be knocking on your door. The deputy won't be asking you to line up. We'll let you take as long or as short as you want in deciding this case. And you'll have all the evidence back in that room with you. So until then, I need you to not talk with anybody about this case. Again, do what you've been doing. You're so good at it. Again, I don't think you're going to see the attorneys this evening. I don't think you're going to see them tomorrow morning. But if you see them or any other witnesses or parties, please excuse them for they're not going to say anything to you in this matter. And even though you have heard almost everything, the word is almost, you haven't heard the law, you haven't heard the closing arguments, so please keep an open mind on this matter. Mr. Malik, would you like any other instructions given to the jury?
No, Your Honor, thank you.
Mr. Clark?
No, sir.
Mr. Davis? No, sir, Your Honor. And Mr. Mosley? Sir. Folks, thank you all. Leave your pads on your plates, on your chair. I have a letter for one of you which need to get to whoever that was supposed to go to. Okay, all right, very good. Again, if you're having any problems with employers at all, just drop me a note in the morning on a piece of paper, give it to the deputy, and I'll get a letter off to you right away. Okay? Thank you all. Thank you for coming back. We'll see you tomorrow morning, probably at 8:30. Let's deal with motions first, then we'll take a break and then get to jury instructions. Motion C and the fine. No, Your Honor. Okay, thank you. I'll ask the state. Any additional motions or any arguments? No, Your Honor. Let me give you all about a 15-minute break or so. It's about the normal time we take one. And then I'm going to ask Mr. Mallon, do you have copies of the instructions for both Mr. Clark and Mr. Davis?
They've been emailed. I have a hard copy with my proposed edits from last night.
And I may make copies of that. Have you made those edits yet?
I haven't made copies of the ones with my edits yet. I have a hard copy.
Can you get with the attorneys off the record before we go back on? Let's see if we can get some brief concept before we go on.
Absolutely.
We'll go off the record officially for 15 minutes, and then once we're ready, we'll go back on. Mr. Davis, do we need to be on the record on your administrative item?
I don't believe so.
Okay. Come on, sir. We'll be recessed.
Let's prove going for it was reasonable doubt as to either knowing